Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. Welcome to our webinar, Latest Regulation Updates on Labor Law and Foreign Worker Permits in Indonesia, which conducted by Suryacipta Centre of Information and Vistra Indonesia. Suryacipta Centre of Information, or SCI, is the free of charge one-stop service in Suryacipta City of Industry to guide the investors to plan, start, and operate their investments in Indonesia with more efficient and effective time and cost. To provide professional advisories, SCI is in partnership with respected consultants and vendors. And Vistra Indonesia is one of the business consultants partnered with us. As we all know, Indonesian government has issued the Omnibus Law number 11/2020, and through the derivative regulations, there are some changes of provision on labor law and foreign worker permits. So now we would like to facilitate the socialization and help you to answering the question of regarding these regulation matters. But first of all, I would like to introduce of our speakers for today. I'm Afita Ratna from Suryacipta as the MC and moderator. Mr. Floris Van Der Velde as the Associate Director, Business Development of Vistra Indonesia. Bapak Rizky Matondang as the Manager of Employment Services of Vistra Indonesia. And Bapak Indra Wijaksana as the Senior Marketing Manager of Suryacipta. This webinar will be divided into 4 sessions. And the first session is opening. The second session is material presentation by our panelists. The third session is Q&A. And the last session is closing. But before we get started, if you have any questions, please do not hesitate to drop the question at the Q&A feature below with format name, company or institution, question, and to whom the question is addressed to. The question will be answered at the Q&A session, and the name of the sender will not be mentioned. Okay, so without any further ado, to start the event, we welcome Bapak Indra Wijaksana from Suryacipta to give an opening speech to the audience of today's webinar. To Bapak Indra Wijaksana, you may give the opening speech. Thank you.
Dear clients and tenants, the recent issuance of Omnibus Law and its application on labor law certainly affect all of us in various extent. It has unavoidably generated pros and cons among business owners, management, and workers. We have also received numerous inquiries with regards to the law from our clients and tenants in both Suryacipta City of Industry in Karawang and our new project in Subang Smart Politan. Today, Suryacipta Centre of Information are honored to welcome one of our respective partners, Vistra, to present more about the labor law in Indonesia. Vistra, with its presence in over 46 jurisdictions across the globe, certainly has the right combination of expertise and experience to assist you with regard to the law. Together, we expect to enrich our understanding and learn more about the latest update of labor law as well as foreign worker permits in the country. I would personally thank Vistra for presenting today and audience for attending this webinar. Please feel free to ask any related question by text via the Q&A button available on the bottom of your screen. Let us begin today's webinar. Afita, please continue with the program.
Thank you very much, Bapak Indra Wijaksana, for your time. And for the next session is material presentation regarding labor law under Omnibus Law overview that will be presented by Mr. Floris Van Der Velde. And to Mr. Floris, you may start the presentation.
Thank you, Afita. Let me share my screen. Yeah, thank you, Afita and Pak Indra for the introductions. Let me first provide you with a quick introduction on Vistra. Vistra Indonesia is located in Jakarta, and we provide a a one-stop service solution on services related to ranging from market entry, company information, business license, advisory, bookkeeping, accounting, tax, expatriate services, and more, enabling clients to focus on their core business. Vistra Indonesia is also part of a global international organization. Globally, we rank among the top 3 players in the world and in the corporate service provider industry. We are present in the meantime over 46 countries, including our latest edition, our office in Japan, and with over 4,700 professionals working to provide solutions for business in almost every industry. So now let's go to the general introduction of the Omnibus Law. I will be shortly talking about the labor law, but it's always good to have a bit insight in the Omnibus Law, of which the labor law is part of. The Omnibus Law is part of the 2045 vision and priorities as set by President Jokowi and his government to become into the top 5 largest economies in the world by 2045. And the Omnibus Law plays a big role in achieving this vision of the government. A few quick highlights and general introduction of the Omnibus Law. As you probably might have seen, there have been strong protests from some specific groups on the road leading to the enactment of the Omnibus Law. However, it was enacted in November 2020. In the meantime, 6 petitions have been lodged to the Constitutional Court to challenge the law. It's fully unclear whether this will have any real effect on revoking of the Omnibus Law or parts thereof. That's just, we have to see how that works out. Just a little bit on the scale of the Omnibus Law. It is seen by many economists and lecturers on the most wide reform since the introduction of the Civil Code in 1847. Well, I mean, that says enough, basically. If you look at the law itself, it's almost 1,200 pages. And the Omnibus Law works as an umbrella law. So it is not one law, it is an umbrella law consisting of changing the 80 laws which it has in it, and which the labor law is one of them. And the topics covered ranged from investment ecosystem, manpower, ease of doing business, regulatory and tax related, land procurement, the economic zones, central government investment. So many topics. The better question you can maybe ask is, which topic is not touched by the Omnibus Law? Next slide. Yeah, general introduction. A quick on the reasons why the government has made this part of their focus and initiative, and what are the conditions leading to the Omnibus Law. Well, economic growth is below expectation already for some years, stagnating, and this is of course not relating to the COVID-19 pandemic, which is of an exceptional nature, of course. Stagnating ranking World Bank ease of doing business, questionable regional competitiveness, included on the labor law regulations, which are among the reasons and conditions leading to this initiative. The Omnibus Law was implemented in February 2021, in which month almost 50 presidential regulations were issued, implementing the separate parts of the law, including some of the labor law. But still, we are waiting for implementing regulations on some of the subtopics of the law. So some details are just not yet known. Well, as briefly said, criticism and protests. Some see it as a rush job, poor harmonization and synchronization with the stakeholders, with ministries, for instance, with the regions, limited public participation. Then the liberalization of the labor market itself is, of course, ground for discussion and criticism from the specific groups. And there are environmental concerns, as well as re-centralization of government power at the expense of regions, which can also be, if it's not good balanced, can lead to discussions and issues. So before we jump into the labor law section, which will be done shortly, I just want to show you this slide because this is the new investment list overview of the positive changes. As everybody knows, Indonesia had the negative investment list that was changed into, some call it a positive investment list, and I would agree it has a more positive stance. So here you see some changes in key sectors, which these sectors, among them are distribution, advertising, e-commerce, construction, retail, hospitality, plantation, and medical, are now almost 100% open for foreign direct investment, or at least significantly more open than before. Although, for instance, constructions, it says 100%, but in constructions, there are some restrictions still. And also, it's good to notice that in May, there has been a revision of the new investment list, which has seen, so it was a little bit a rollback of some of the topics. For instance, e-commerce, there are now more restrictions in place. Of course, we have seen the alcoholic beverages, which was suddenly open for 100%. Also, some specific groups had some feedback, and that is now rolled back, pushed back. So this is just to show you that in terms of foreign direct investment and an investment list, it's a big positive change in many sectors. Right, now let's go to the labor law part. So before I jump into some of the main changes in the labor law, just want to provide you a brief introduction of what is the main reason of the whole new labor law and the flexibilization of the labor market. I think that's also good to realize. Indonesia's current demographic profile presents a substantial major pool of labor resources, as we all probably know. It's a fourth populous nation in the world with huge potential. But if it's effectively managed and engaged, it can help drive economic growth and increase Indonesia's competitiveness. However, labor force productivity in Indonesia is still viewed by, specifically by foreign investors, as a potential stumbling block to the attractiveness of Indonesia in terms of investment destination. And this is particularly the case when compared to some neighboring countries in Southeast Asia that typically compete with Indonesia for these investment dollars. So it is for this reason, and is one of the reasons, that the Indonesian government recognizes the need to focus on creating an environment, including the regulatory framework around it, that can support the improvement of labor force productivity. So these changes of the labor law are expected to support the improvement of the labor force productivity rate and competitiveness, while also provide a sufficient protection to employees. That's of course one of the main parts of the labor law where all the protests were about. So the hope is that this in turn will create increased job opportunities and further develop the Indonesian workforce. So let's go to some of the main changes in the labor law. To start with wages, the minimum wage by sector is removed, but regional minimum wages remain in place. This basically means that governors across Indonesia will determine the minimum wage of each region. And they do that based upon the inflation rate and the economic growth in that region. So not nationwide, but they can do it per region. So better to reflect the need for salary adjustment in that region. Labor intensive sectors, for instance, like I guess many of the tenants are, will not have to adhere to regional minimum wages, and governors of the respective provinces will use different formulas in their calculations. Also, it's good to say that micro and small businesses are exempted from the minimum wage stipulation, but they must pay their workers above the poverty rate. Work hours, that has become more flexible. It is internationally seen capped to the usual 40 hours per week, 5 days per week. That's pretty standard. However, employers can now divide the hours over a week in a more flexible way. Starting and ending hours in starting the day and also in the weekend to better align with specific requirements of the job concerns. because it depends on the job sometimes, you know, how you would divide the hours in a week. Beyond this, employers must pay overtime to workers, but not exceeding 4 hours a day and 18 hours a week. So that's the maximum, 4 hours a day and 18 hours a week in total. Change to fixed terms agreements. This also used to be that after 3 fixed terms agreements, so let's say after 3 years employment agreement of 1 year, after 3 years, you need to go to an employment agreement for an indefinite period of time. That has been broadened to a maximum of 5 years for specific types of work. Let's go to the next slide. Okay, I will highlight here some other, still the main topics of changes in the Omnibus Law, labor law. Termination of employees is still difficult, but some new and amended termination reasons have been added into the new labor law. So previously, the grounds of termination were very minimum. Now they have added acquisitions. So mergers and acquisitions. Mergers were still was already in labor law, but now it's including acquisitions, divestment, efficiency. It's an important one. Business closure after 2 years of losses is now also ground for termination of employee. Debt restructuring and bankruptcy. May seem obvious, bankruptcy, but that's not included in the law. There's also a new unemployment scheme. This is totally new. I will discuss a little bit more about this. So the government incorporated a new unemployment benefit and job seeker assistance scheme in the new legislation. It's called JLSP. So rather than being established as a standalone scheme, it is fully integrated into the National Social Security Program, NSSP, which is operated by BPJS. There is a mandatory participation for all formal sectors employees and employers. That ranges from sole traders to multinational corporations. So it covers every employee and employer in the formal sector. However, the scheme does leave a number of gaps. For example, it only applies to existing employees. So those looking for a new job or long-term unemployed are not covered by this scheme. Further, the informal sector is completely excluded. So despite employing 50 to 60% of Indonesia's workforce, according to some estimates, they are not covered by this unemployment scheme. So it does provide a welcome breathing space for workers who lose their jobs, but it does not attempt to provide coverage for all. So who is eligible for participating in this unemployment scheme program? As said, existing employees who are enrolled in the NSPP at the time of commencement of the unemployment scheme, and new employees who must be enrolled by their employers. They are automatically, by that fact, become part of the scheme. All participants must have the Indonesian nationality. So this is not for expatriates unless they have the Indonesian nationality, under 45 years of age, and they must be in a working relationship with their employer at the time. Benefits. What are the benefits of the scheme? The program offers participants more or less 3 benefits. The most important one is a cash benefit. So the first 3 months of unemployment, 45% of the monthly wage is paid out under the scheme, and the next 3 months, 25% of the standard wage, of the monthly wage you had before unemployment. You get access to labor market information, and you can get job training. It can also be a combination of the 3. Both permanent and non-permanent employees may access the scheme's benefits, provided that they have been terminated by the employer and have fulfilled the minimum contribution requirements before termination. To my current, to the knowledge we now have in the regulation, so the premiums paid by the employer to the unemployment scheme must have been paid 12 months before that. So if you are relatively new in the employment scheme, say 3 or 4 months, you have only paid 4 months of premiums, you probably won't get the benefits under the scheme. An employee who resigns himself voluntarily or suffers this permanent total disability or retires is not eligible for the benefits on their JLS. Severance package. A lot has been said, of course, about this. This is for many workers one of the most sensitive topics, and of course, for them of importance. But the severance package is less high under the new labor law, and I will in a further slide elaborate a little bit more on this. It's actually this slide. Well, a few key changes here, but most of them I have already discussed actually. One of the things I have not mentioned is outsourcing. The rules on the type of work and jobs that may be outsourced are also relaxed, made more flexible. Under circumstances, and the regulation needs to be checked for the details, it can also be now core work or important work that can be outsourced. It always used to be outsourced work of others than the main core work, basically. On the bottom part of this slide, I have put an example of severance pay, which an employer needs to pay before and after the labor law. So let's see. And this example works for an average of 10-year employee. If an employee is terminated for misconduct, previously the employee was eligible for 11 months salary, and now it's 4.5 months salary. Efficiency, if that's the reason for termination, that's a pretty big difference, but it is understandable because previously it's 22 months salary which was needed to be paid. Now it's 9 months salary, and force majeure is more or less the same. So I'm not going into if a severance package how. Let's say on a political sphere, but when you look at the region, the severance package has been brought more in line with neighboring countries, basically. Next slide. It's my last slide before we go to my colleague who will discuss more on the expatriate services and foreign. Apologies. So for expatriates, foreign workers, in high over, you can say there are no major changes. Certain positions are excluded. One of the changes is that certain positions are excluded from having an Indonesian mentee and training requirement. And for instance, for expatriates working in certain businesses or areas like tech startup or vocational work or temporary research, there is no RPTA approval anymore required. So this basically means that getting a work permit for these expatriates who work in this type of business has become more easy. I've come to the end of my slides, and I would like to hand back to Afita.
Thank you very much, Mr. Floris, for your presentation. Dear all audience, if you have any questions, you may directly drop the question at the Q&A feature below, and we will continue for the next presentation regarding foreign worker permits in Indonesia that will be presented by Bapak Rizky Matondang. To Bapak Rizky, you may start the presentation.
Yeah, thank you, Ibu Afita, for the introduction. Yeah, my name is Rizky Matondang. I am with Vistra Indonesia Employment Services team, and I'm going to speak about the work and residence permit for foreign workers in Indonesia. And let me start with some good to know information on expatriate working permit in Indonesia. There are more than 90,000 expatriates registered in Indonesia in 2020, and mainly from Asia country, and mostly working in construction or engineering sector in Indonesia. And also, work permit in Indonesia is only applicable for professional and managerial position in the company. And here is the regulation transition on foreign worker utilization plan, or the RPTA, because previously it is regulated on the Presidential Regulation number 20, year 2018, and amended to recently issued Government Regulation or Peraturan Pemerintah number 34, year 2021, with the implementing Regulation number 8 of 2021. As previously, it is a Ministry of Manpower Regulation number 10 on the year 2018. Actually, there is no significant changes on the Government Regulation number 34 and the Ministry of Manpower Regulation number 8, as you may see on the next slide. And here are some of the highlights on the Government Regulation number 34. And as you may see on the Article 5, the double position on the second companies are still only applicable for Board of Director or Board of Commissioner, and with some additional exception for vocational education, digital economic, and oil and gas sector. And on the Article 6, sponsor companies still have to obtain the RPTA for foreign worker, but this is with some exception for several positions. And local worker companion or Indonesian worker companion is still mandatory, with some company obligation to the foreign worker, as may see of returning the foreign worker to the origin country, or education and training of Bahasa Indonesia. And yeah, BPJS registration is also mandatory for a long-term working permit for the expatriate worker, let's say for more than 6 months of RPTA validity. And restriction on double position within the same company is still also restricted by the Indonesian government. And there are several types of RPTA now to be applied for a foreign worker. And it can be matched with the need of the company. For example, for a short working period, the company can apply for a short-term RPTA, which will be valid for 6 months and cannot be extended. So, and on the Article 19, the RPTA is not, cannot be applicable for a Board of Director or Board of Commissioner with a certain amount of investment by applying for an investor visa or visa 313 or visa 314. The non-RPTA is also applicable for a very urgent matter. So if with the urgent cases within the company, like the machinery malfunction or the force majeure that can cause the company a huge loss, then an RPTA will not be needed. The company just need to apply for a visa, basically a single entry visa that will valid for no more than 6 months. And on the next slide, there are some employer obligation and restriction. Here are some of the summary that covering the obligation and restriction. It's both for companies, for sponsor company or the employer. And as mentioned on the article, on the previous Article 7 and on Article 8, there is some exception for several positions. Let's say for next slide, sorry. Yeah, for the employer obliged to appoint a local worker and appoint returning the expatriate worker to the origin country and registering for the social security program of the BPJS, and also provide training for non-director or commissioner, and employer also required to submit an annual report to the Ministry of Manpower regarding the foreign worker utilization or the RPTA on how many expats in 1 year that you employ. And also there's some restriction on the recruitment. An individual cannot employ a foreign worker, and a foreign worker cannot have a same position within the company. I mean the double position in the company, and also personal position or the HR position. And on the next slide, here are some the application work and residence permit application process. Basically, it's remained the same with the previous regulation. It started with the RPTA, and then it comes with the notifikasi, or formerly known as IMTA. And then once the IMTA is issued, the visa process will be automatically started by the Indonesia immigration. And it is now called the e-visa, or the e-visa 312 for the working, and previously called telex visa. With this e-visa, you don't have to, the applicant, you don't have to collect the visa anymore at the Indonesian embassy like the previous telex visa. With this type of visa, with the e-visa, the applicant can come to Indonesia directly, and once they enter Indonesia, the kitas will be issued automatically by the Indonesian immigration. And speaking of the immigration, this is the regulation transition on the immigration. It is the implementation of Law Number 6 of 2011. Previously, it is a government regulation number 31 2013, and being amended to government regulation number 48. It is the implementation regulation of the Law Number 6 2011. As you may see, this is the difference, the summary, what is before and what is after, what is on the government regulation number 34, and then the government regulation on the number 48. As you may see, there are some additional changes. There are some additional and changes on the government regulation number 48. The additional includes the pre-investment visa, the parcel slip to the immigration, second home, and visit visa validity. The pre-investment visa is for investor with a sponsor company in Indonesia for visa application. And this type of arrangement will require a certain amount of deposit to the Indonesia immigration directly. And however, we're still waiting for further instruction from the immigration on this, because it's not been really implemented yet at the immigration. There's also additional requirement, as you may see on the article 103 on section C and D. The additional requirement is a certificate of good conduct. It is basically like the SKCK from the expatriate origin country, and also there's a health certificate that needs to be obtained from the local authority, like the local hospital or Ministry of Health from the origin country, basically free from dangerous and infectious disease for a visa application. And also there is a changes on the visa on visas on arrival, the stay permit on arrival validity. With previously it's only valid for 1 month. Now it is extended to 180 days. And also the changes is on the single entry and multiple entry visa, because previously the single entry visa is only valid for 60 days after the entry of to Indonesia, and the multiple entry will valid for 1 year with the expatriate having to exit Indonesia every 60 days for in the range of 12 months. Now both of the visa will be valid for 180 days. The only difference is the multiple entry visa can be extended for up to 12 months upon the arrival to Indonesia. And if we go to the next slide, this is some of the type of visa in Indonesia. As you may see that we have a single entry visa, multiple entry, and visa on arrival. However, as of today, this is still not fully implemented by Indonesia immigration, because the before and the after is what is the plan by the immigration to amend the validity of the visa. But as of today, it's still not being implemented yet, and the visa on arrival is also, as you may know, still closed by the Indonesian government. And also there's a limited stay permit, or we usually call the kitas or the kitab. And as of now, the kitas is valid for 1 year, and it is extendable up to 5 times with 6 years total validity. And then the permanent stay permit, or the ITAP, is valid for 2 years with a multiple entry permit. But however, the immigration is planning to extend the validity of the kitas into 5 years. So there's no more kitab, there's no more kitas, there's only stay permit that is valid for 10 years and with maximum of extended to 10 years. Okay, and for the next slide, this is the obligation and restriction for the sponsor. There are some obligations for the sponsor of foreigners in Indonesia, as every foreigner in Indonesia must have a sponsor for the visa, unless for the pre-investment visa or the foreigners who married to Indonesian citizen. And this is the deposit. What I'm talking about in the previous slide on the immigration or the immigration guarantee. This deposit is it's not implemented yet by the immigration, and the purpose of this deposit is for a foreign investor who don't have a sponsor company that is willing to come to Indonesia, and this is the soon to be implemented by the immigration. And also, if we go to the next slide, here's some of the essential knowledge for both sponsors or foreigners. During this current situation, visa application can be quite hassle due to the limitation on the quota for the visa application. And as of today, only a single entry visit visa can be obtained. The immigration haven't opened the multiple entry visit visa yet. And as of today, the visit visa is only single entry, which is valid for 60 days. And 5 days quarantine is mandatory when entering Indonesia, with the possibility to be extended to 14 days, according to the latest rumor. But we haven't received any update yet on this quarantine period. And also, please ensure that the job title on the notification or on the work permit is aligned with the foreigner's business card, because in case of inspection, this usually will be an issue if they found out that the INTA is not aligned with the business card. And also, please always keep the documentation like passport, work, or stay permit with you at all times in digital format or in hard copy in case of inspection. It is always good to have your work permit in the phone. And always report any changes on work or stay permit related to the related authority, to the Minister of Manpower or to the immigration. And here's the summary. As you may expect in Indonesia, the rules and regulation might change without prior notice, especially during this current situation. And as of today, only company who can obtain a BKPM recommendation letter is allowed to apply for a new work and residence permit for expatriate worker. And also regarding the job title, it must be accordance to the Permenaker 228 on 2019, and which will be amended soon, but we still haven't got any date on the amendment of this regulation. And 10:1 local expat ratio is still applicable, even though the regulation has been revoked quite sometimes. And also, personal tax ID registration is mandatory for foreign worker who works in Indonesia for more than 180 days. And as I was saying, the current regulation on work permit for foreign worker related is essentially the same with the previous regulation. There's only changes on the terms and required documents, but most of the new regulation of the immigration is also not fully implemented yet during this current situation. And yeah, I guess that's all from me. Off to you, Bu Afita. Thank you.
Thank you very much, Bapak Rizky Matondang, for the presentation. Ladies and gentlemen, now we get into the Q&A session. And right now we already have some questions here. So the first question is to Mr. Floris, and the question: if we hire an employee under a fixed term or temporary contract for 1 year, does it mean we now need to pay 12 months salary plus 1 month THR or THR plus 1 month compensation? Dear Mr. Floris, you may answer the question.
Thank you, Afita. I think that's the case, but let me look into that after the webinar to double check, and I will get back with the decision answer separately to the attendee who posed this question.
All right, sure. And for the next question, hello there. would you please reshare the provision on severance payment, especially under misconduct clause? Because I can't seem to find the clause of it. This question is for Mr. Floris as well.
Yes, we will provide separately after the webinar the relevant provision.
All right. So we will share the material presentation to our audience. And yes, for the next question, it's still for Mr. Floris. Can we still use the clauses in Labor Law number 13 if the clauses give more advantages or benefits to our employee?
Labor Law number 13. I will need to look into that after the webinar, and I will get back to the attendees separately.
All right. And okay, so the participant also asking, if you don't mind, after finish meeting, may I get the material presentation from the panelists? Sure, we will send the material presentation after this webinar event. We will send to the email address that you have registered for this webinar event. And for the next question, I think to Bapak Rizky Matondang, it's regarding foreign worker. And the question is, can GM or SM level of TKA or foreign worker have two positions in two different companies, like in company A as GM and another company B as SM? Company A and company B can be sister companies and might be completely two independent companies too. To Bapak Rizky Matondang, you may help to answer the question.
Yeah, according to the regulation number 34, the government regulation number 34 is only board of director of board or commissioner that can have two positions in two different companies. And it is also needs to be proven by the company notarial deeds. The applicant must be registered at the company notarial deeds. So for general manager or senior manager, the expatriate cannot have a double position, even though the company it is a completely different companies.
Thank you very much for the answer, Bapak Rizky Matondang. And now we also have another question. I think it's for Bapak Rizky Matondang. It's regarding government regulation number 48/2021 start become effective and fully implemented. Do you know, I mean, the regulation, is it already effective and fully implemented right now? And 211A with 180 days valid period, it will be very helpful for foreign businessmen.
Yeah, the visa, the single entry visa or the 211A visa is currently still valid for 60 days. And I've asked several times with the immigration. I tried to clarify several times with the immigration on the validity, because the regulation have been issued, but it's not fully implemented yet until further notice from the immigration, especially during this situation. They also limiting the number of application per day for single entry visa. So I guess after the COVID is slowed down in Indonesia and everything is getting a little bit settled, I think we can have the update of the implementation of the government regulation number 48, 2021. Thank you.
Thank you very much for the answer, Bapak Rizky Matondang. And another question, under the new unemployment scheme, it's for Mr. Floris. The question is for Mr. Floris. Under the new unemployment scheme, the JLSP, how many months pay can there be for an ex-employee?
Thank you for this. It's a good question. under the new unemployment scheme, there will be a maximum of 6 months pay in total. For the first 3 months, it's the 45% of the monthly wage, and then the last in the following 3 months, it's 25%. That will be the cap on the cash part under the unemployment scheme. Back to you.
Thank you very much for the answer. And I think this is the last question that we will answer for this live session. What is the maximum severance period paid to employees under the new labor law? It's for Mr. Floris.
Thank you. So in total, the severance package has been reduced, as we have seen. Under the new labor law, the maximum severance pay has been reduced from a maximum of 32 months to 19 months. So of course, depending on the length of the employee, let's say an employee works already for 20 years, then you normally are in the highest cap of the severance pay. There's now a maximum of 19 months for those workers.
Thank you very much for the answer. I'm sorry, but there are another question that maybe we can answer for this live session. This question is for Bapak Rizky Matondang. Is possible the expatriate has a KITAS, limited stay permit, to live in Indonesia without having RPTA?
Yeah, it's actually possible, especially for the foreign investor, what I mentioned before, by having the recommendation letter from the BKPM and then apply for the investor visa. And also for expatriate who is married to Indonesian citizen, just can apply for a family visa. So the type of like investor visa or the family visa, it is not required an RPTA to apply for. Thank you, Bu Afita.
Thank you very much for the answer. So right now, due to the limited time we have for today, there are some unanswered questions in our live session. Those will be answered by email together the deliveries of our presentation material of today's webinar. And now, dear ladies and gentlemen, now we get the final session. Thank you very much for joining to our webinar today. We understand that the information provided may still have not answered all of your inquiries. So should you need any further information or assistance, please do not hesitate to contact us via email at info@suryacipta.com or phone at +62 267 440088. And a recorded version of this webinar will be available on our YouTube channel at Suryacipta City of Industry. Once again, thank you very much for your participation. We hope that this webinar will be beneficial for you. And thank you to our panelists for today. And good morning and stay healthy. See you on our next webinars. Wassalamualaikum warahmatullahi wabarakatuh.